May it please the court, Your Honour, my name is Crumpler, Crumpler, initial R, appearing on behalf of the appellants Barry and Dr. Wendy Green in this matter. With Your Honour's permission, I will limit opening statements to 5 minutes. We will be opening with submission points regarding natural justice. Your Honour, my clients have recently become parents and have had their registration of name application rejected by Births, Deaths and Marriages as to the name Bendy Anid Green. Your Honour, my clients chose this name as it is a personal meaning, being a combination of both of their first names, Barry and Wendy, and also bears as a reference to a poem from ancient Greece as attested to by Dr. Green's specialisation of ancient literature. On the 10th day of March, my clients received an informal letter stating, and may I quote, "There is no way we are going to allow the child to be called Bendy. I'm sure you can see this is a ridiculous name. We don't want to formally reject it. Can you please reconsider and provide a new registration application? Signed, Edward Burrito, Assistant Deputy under Registrar of Names." On the 2nd day of April, my clients then received a letter from a Miss Alison Ristanjali, an officer delegated to make decisions under the Births, Deaths and Marriages Act of 2003, further informing them that the registration for the as-mentioned name would not be formally registered under Section 12(3)(a) of page 13, with reasoning given by the authority that the child would come under ridicule for such a name as Bendy, and that the name equates to a vulgar word in the Ishinabu language of Inner Himalaya. Also referenced in the letter was an investigative report initiated by a Miss Alison Ristanjali through her department, having liaisoned with a specialist in Himalayan languages, who concluded that the etymology of the word Bendy corresponds with a Romanized version of the same name. Your Honour, we feel that the Department of Births, Deaths and Marriages have not made the departmental decisions regarding my client's child with appropriate conduct, and that there seems to be a level of bias with Edward Burrito's statement that, may I quote, "I'm sure you can see this is a ridiculous name." May we refer to the laws for natural justice under the hearing rule, that my clients have a right to be shown all of the material, and that there is a consideration of this material, and that they have a right to be heard in an unbiased manner and to know the case against them. My clients have not been given the reports as mentioned previously by the department from either Alison Ristanjali or Edward Burrito. Your Honour, may I bring to your attention decisions not binding on this court, but that show similar facts. Kanda versus Government of Malaysia, 1962, AC 322, and ACT Commissioner for Revenue versus Alpha 1, 1994, 49 FCR 576. My clients have not had the opportunity to see either reports, therefore cannot adequately make an informed decision to change the name of the child within the 14-day period as stated under Section 12(5)(a), subsection 3, page 14 of the Births, Deaths and Marriages Act, as there has not been an adequate provision of time for my clients to receive these reports, and thus rely upon the information reported in them as to make a reasonable decision between them both on the proposed name of their child. Your Honour, under natural justice, my clients are asking for this case to be dealt with impartially and with fairness, and to prove to this court that my clients have a constitutional right to know the case against them and to be given the opportunity to see the evidence as per the department's report against the decision to not register the said name. To conclude, the Department of Births, Deaths and Marriages had no valid reason to not provide my clients with the reports, and we ask the court to remit the decision of the Department of Births, Deaths and Marriages based on the statutory requirements regarding these matters concerning the decision of the delegated persons acting on behalf of this department, and to further take into consideration the Administrative Appeal Tribunal Act of 1975, Section 43, Chapter 1. My clients would like to resolve this matter efficiently and settle without any further legal action. Thank you, Your Honour.